So Section 230 was passed in 1996 in response to a few lawsuits and court cases, especially Stratton Oakmont versus Privacy Service Co., which moderated some posts and was found liable for all of them. So a law got passed to say the websites cannot be found liable for most posts because they are not to be treated like publishers. They're not responsible for what you post. Since we have long evolved from the internet's early days, Section 230 has led to some very dangerous legal and ethical situations. We split up liability of Section 230 cases using this analytical framework to study how corporations can be found legally liable for actions despite their Section 230 protections. Surprisingly, they can be found liable a lot. For a direct liability bucket, essentially sometimes websites are publishers, or at least they are responsible for what got posted. The most interesting of these Section 230 exceptions is when the platform does something with your post. If they promote, manipulate, and or profit off your post, the likelihood of them keeping their 230 immunity goes way down. Another type of responsibility is indirect liability, which in the law means that it wasn't the company's actions that violated the law, but rather their lack of action or their supplemental action to a third party. This means failing to uphold privacy laws, antitrust laws, third-party transaction laws, etc., all of which can be called negligence.
So the first topic relating to accusations of direct liability is algorithms promoting content. These accusations are about anything having to do with how companies automatically show users content, products, or results to queries. The biggest cases almost always involve social media sites, search engines, and online vendors. Judges actually ruled on 3 similar cases about terror attacks in Paris, Istanbul, and San Bernardino. All 3 were victims of the terrorist attacks against Google, Facebook, and Twitter. They say algorithms recommended videos to watch and people to follow, and that since the recommendations are created by the companies, they should be held liable. Cases have been denied previously because reasons used were protected under 230 specifically. For example, a man bought heroin from a message board and died, but they ruled it was not actively promoting it. Again, one person tried to say they were aiding and abetting a terrorist attack. Judge said it wasn't a direct relationship. The Istanbul case was the only one to be revived because the plaintiff argued that approving monetization was knowingly sharing revenue with a terrorist group. However, all 3 judges did agree that Section 230 needs to be changed, and the beginnings of a new bill to place responsibility on companies is already being started.
Consistent with its intent to foster the growth of the internet, when Congress first drafted Section 230, it specifically exempted intellectual property law, as IP rights are crucial for the internet's success. This means that computer service providers are still liable for intellectual property violations posted on their platform and must comply with DMCA regulations or be held responsible. Consistent with its intent to foster the growth of the internet, when Congress first drafted Section 230, it specifically exempted intellectual property law, as robust IP rights are crucial for the internet's success. This means that computer service providers are still liable for intellectual property violations posted on their platforms and must comply with DMCA regulations or be held responsible. In 2001, a web hosting company, Mindspring, hosted a site that violated Gucci's trademark. After requesting that it be taken down multiple times, Gucci sued Mindspring for trademark infringement. Despite this type of content usually falling under Section 230 protections, because of the IP exemption, courts still held Mindspring responsible for the violation and upheld the lawsuit. This pattern is consistent among other cases, but one area of disagreement is whether the same logic applies to state laws or only to federal IP law, as some states have expanded their protections past federal law. The Ninth Circuit held that it did not apply to state law, holding that service provider CC Bill was immune from a right of publicity lawsuit brought by Perfect 10 under state law. However, recently, the Third Circuit disagreed. In a similar case, the Third Circuit found that Facebook was liable to state law right of publicity suits brought in response to content posted on its site. Here, the court found that the IP exception did include state IP laws, and thus Section 230 protections did not apply.
As you may know, Snapchat used to have a speed filter that displayed how fast a person was traveling when they took pictures. It was released in 2013. Over the years, many teenagers wanting to see how fast the speed they could capture used the filter while driving recklessly. This caused multiple fatal car accidents, and the filter was ultimately removed in 2021. Various people sued Snapchat and argued it was negligent in creating the filter in the first place. This was a standard products liability lawsuit, like those against lawn darts. The linchpin of Section 230 provides immunity to websites serving as publishers of content created by others. There is a misconception that the law provides blanket immunity to websites, but that's not true. Websites can be held liable for content that they create themselves. Last May, in Lemon versus Snap Inc., the Ninth Circuit Court of Appeals in San Francisco sided with parents of one set of teenagers who died while attempting a speed record. The court held that since the filter was Snap's own creation, the parents' products liability action was not barred by Section 230.